Good morning, friends. In our webinar session, we've been discussing about the IPRs. The first week, we discussed about the IPRs in India, the patent officers, and patent history. The second week, we discussed about the patents, the concept, predominantly making an application for patent, grant of patent, and how you will be opposing the patent. And finally, if there is no opposition, how the patent is granted. Today, we will move on to see in the patent some of the important and interesting provisions, and we will conclude with an interesting case law, friends. I sincere thanks to Hari and Aishwarya for this contribution. In continuation of previous week, we will just have a quick glance of the patent filing process. Patents Act, read with the relevant rules and regulations where the forms are prescribed and what are the respective forms when you make an application, when it is for provisional or complete specification, when you are making an opposition, or when there is going to be an application which is made by persons outside India. Secrecy of certain inventions. So how this particular secrecy concept applies and what is the role of a controller and what is the discretionary authority of central government to decide whether it is going to be prejudicial to the general public or not, and coming to a conclusion to lift the secrecy in case of certain inventions. Patents of addition, where there is going to be an improvement or modification to the main invention. What is main invention? Main invention is when you make an application in Form 1 and when you are also going to make an application for provisional complete specification in Form 2. So where there is going to be any addition in terms of modification or improvisation to the main invention, there comes the patents of addition. Under secrecy of certain inventions, we are also going to see when there is an application made by residents for such patents or inventions outside India. Restoration of lapsed patents. What are the necessary criterion under which this particular patent gets lapsed or cancelled or annulled, and what is the foremost step which you have to apply to ensure that your patent is not getting lapsed, having taken all the humongous efforts to make an application and get the registration done. We will conclude with the case law on the subject matter when the controller has the authority to determine if you are not going to make the payment of the annual fee within the time prescribed, how it is getting lapsed and how you have to go for pleading and making an appeal when there is an opportunity of being heard for the aggrieved party. Let's have a glance at the patent filing process. In Form 1, you are making an application for grant of patent. And Form 2 is for making an application for provisional or complete specification. A request to publish the patent comes in Form 9. And in Form 18, an examination of your application is done. Opposition for grant of patent is made in Form 7A. Finally, your patent is granted. Friends, we are aware that it is a costly affair when it comes to hard copy submission in physical mode. Thus, the first schedule which talks about your fee says that fee for physical mode is 10% higher than what you do through online submission. And patents, you have this facility of both e-mode in your formal intellectual property official site or by submitting the hard copy in the respective patent office, where we have already discussed the relevant jurisdictions where the patent office is sitting. Next comes the important provision, secrecy of your certain inventions. Patent application is filed by an applicant. There are two ways to look at it. First is the controller's authority view, where an invention falls under the category notified by central government. That is, certain classes are clearly mentioned by central government to be of utmost secrecy. Then this invention is construed to be falling within that particular ambit. Thus, the secrecy direction is notified. It will be issued when central government is satisfied that this publication would be prejudicial to the defense of India and hence to protect the national interest and sovereignty, more importantly the security. The central government, together with the controller's view, exercises this particular authority to impose the secrecy direction. It will be revoked by the controller when it is a concluded decision that it is not prejudicial to the defense of India. The second way is when the controller is not issuing any direction, which means this particular invention is not falling within the class as notified by central government. But it does not appear to the controller to be relevant for issuing secrecy direction. Here comes the authority of central government, where the central government is of the view that the invention should not be published. It will then impose the necessary discretionary authority and inform the controller to issue such secrecy direction. So that is with regard to your way 2. Way 1 is when the controller suo motu exercises the discretion, and way 2 is when the central government is of the view that this particular invention should not be published. Then publication will be restricted to protect the interest of the nation. Points to be noted for issuing this secrecy direction. Point to be noted that the time limit for issuing such secrecy direction is not specifically spelled out in the Act. We all are aware that the main application comes in your Form 1 and Form 2. So the time to issue secrecy direction is 18 months from the date when the application is caused to be made or the priority date. Last week we discussed about the priority date as well. So Form 1, Form 2 made by the applicant together with Form 9 where he is making a request for publication of this particular patent. The time thus to issue the secrecy direction is anywhere between your application stage and more importantly prior to your publication stage. Power to issue and revoke the secrecy direction lies only with the controller, because we read in the previous slide that the way 1, the suo motu authority is thus lying with the controller, and only when the class is not notified within that particular ambit and the central government is of the view that it shall not be published, then the central government decides whether it is prejudicial to the interest of India or not, and then again it passes on its direction to the controller to impose the necessary secrecy directions. Removal of secrecy direction by central government. The Act prescribes a mandatory time as every 6 months. Publication of invention no longer considered to be prejudicial to the defense of India. So, every 6 months is when this particular invention, there is an acid test made whether it is prejudicial to the defense of India or not. Or when the applicant in his interest makes an application to the authority who has the necessary power to issue the secrecy direction, that is the controller. This invention is already published outside India, is the contention of this particular applicant. Then this is applicable only in the case of foreign applicant, because they are of the view that it is already published outside India. In which case, this removal of secrecy direction will be considered by central government, provided it is not prejudicial to the sovereignty of India. During the year 2018 to 19, 98 applications were given secrecy direction. The same were referred to DRDO, of which 59 applications had been cleared for normal proceeding and 39 were pending with DRDO. This is from the official source of Intellectual Property India annual report. Now let's see some of the pros and cons of issuing this secrecy direction. Invention which lies under the secrecy direction, anywhere between your application stage, that your Form 1 plus Form 2 to the stage of grant, then such order could be passed by the controller between these two stages, and no appeal shall lie against the controller provided it is within the time gap as specified herein. The stage of grant is the grant of patent or revocation of this grant of patent as the case may be. 100 101, 102 of the Patent Act deals with the inventions which are used for the purpose of government. There are certain inventions where the government considers it to be relevant or for the utmost utility of the government. Then if such invention is being used, it will be treated on par with the invention for which the patent is granted. Granting of patent to that particular applicant is thus kept on hold for the usage of government. However, if this particular patentee is going to suffer any financial hardship, he will be provided a compensation in the form of filiation. And no renewal fee shall lie in respect of this period during which the direction is enforced, because already it is being effectively utilized by government. So these are a couple of advantages, whereas the drawbacks are you have to wait until the controller is going to lift that particular secrecy direction, and which is between the stage of your application and the stage of grant. Next comes your patent application outside India by residents. It clearly carves out the persons who are resident outside India. Thus, this provision is not applicable to persons who are resident outside India. If the resident has made an application in India not less than 6 weeks before making an application outside India, so that cooling off period is minimum of 6 weeks. So application is thus not allowed if an application is made by the resident for a period less than 6 weeks, and application with prior permission is allowed, and the prescribed form is Form 25 when there is no secrecy order issued, which we have discussed just now. Which means, and it implies that where there is a secrecy order in force, no application shall thus lie. If the resident wants to apply outside India before making an application in India, prior permission is thus required. Where this application is allowed with prior permission, controller is provided the prescribed time being 6 weeks, within which he shall determine whether the secrecy direction is required to be imposed or not. Central government shall also be consulted in this case of invention whether it is relevant or pertinent in the case of atomic or defense purpose which is being utilized or not. The response to this application made in Form 25 shall be made within 21 days from the date of application, or response from central government with regard to whether it is for atomic or defense purpose, as the case may be. IP India Annual Report again provides this statistics that out of 5,852 applications filed, permissions are thus granted for 5,713 applications. Almost 99% of the applications are thus granted on merits. Next comes your patents of addition. Main invention, we already are aware that the one which you file under Form 1 and Form 2, your main application together with your provisional or complete specification, and where there is going to be any modification or improvement caused to this particular main invention. Who can file? The applicant or patentee is allowed to do this addition, patent of addition filing. When can it be filed? You could do simultaneously with your main invention application, or subsequently when there is any accretion to it, you could do the filing. Is it possible to do before applying for main invention? No, it is thus not possible. And when can the grant be given? Only after or together with the granting of patent for your main invention. So it could also synchronize, but certainly not prior to that. Terms of patent of addition. Again, interesting facts. Date of grant, main invention, say 31st March 2020 as an illustration, and your improvisation for which the patent grant is on 31st March 2025. The validity is 20 years, though the patent of addition is subsequently done. The 20 years starts from the date of your main invention. So it gets reckoned from 2020 and not from your 2025. That is your addition. So the earliest possible date is reckoned. However, if there is going to be any extension and you would like to consider this 2025 as the earliest possible date to be reckoned for your 20 years, you could do so, provided that it is filed as an independent patent and not as a patent of addition. For this, there is no renewal fee is thus clarified, where this is going to be an extension from the original patent. Okay. However, you will have renewal fee if there is going to be a separate patent, an independent patent, which is going to be like a separate invention by itself. Novelty of patent. Patent of addition should be seen in conjunction with your main invention. So it is acting as your subset of the main set, which is your novelty of main petition, and it should not be looked as a separate entity. Finally, we are going to see the restoration of lapsed patents. Very important. Application shall be made in Form 15 for your restoration of lapsed patent, which is going to be of not having any effect if the renewal fee is not paid within the stipulated statutory time, or it is not being extended within the statutory time frame. For instance, if the principal patent is granted within 2 years and subsequent year renewal fee payment has to be paid in advance for every respective year, or if due to some unavoidable reasons you could not make an extension, you provide an explanation and comply with it. So Form 4 could be filed with the controller explaining the opportunity or explaining the situation leading to this particular failure to do an extension before this particular time for extension of 6 months. The second instance is the principal patent is granted later than 2 years from the date of making the main application. Renewal fee has to be paid within 3 months, or Form 4 could be filed with controller for extension of 9 months. Application for restoration shall be made within 18 months from the date of lapse of the patent, either by the patentee or the legal heirs, or by 2 or more persons jointly. This statistics from annual report of IP India says that out of 141 applications filed for restoration, 84 applications were restored. The procedure for restoration is thus: you will provide explanation for failure to pay renewal fee which was unintentional and there had been no undue delay in making an application. If the controller is satisfied with your explanation, he could publish the same for opposition. Where there is no opposition, on making a renewal fee deposit together with the additional fee because of the extension period which you have opted, the patent will be restored. Or if the interested party, we already studied last week about who is an interested party. He is against these two categories and he wants to make an opposition. Such opposition is filed in Form 14. And where the decision is in favor of this opponent, patent will not be granted and it will be made available to general public. When it is made available to general public, it is implied that no royalty needs to be paid to the applicant or the patentee. And they could, in the sense, the general public could use the patent once it is lapsed. In order to protect and compensate them, controller may thus issue direction to the patentee to not commence any criminal proceeding against such general public. Thus, the statutory protection available is from the date of lapse of patent till the date of publication of patent. For restoration, there shall not be any prosecution or other legal proceedings imposed, and the general public will be free to use it without paying any royalty. We will conclude today's webinar with an interesting case law on this particular subject of restoration of lapsed patents. This Mannesmann AG of Mannes Manufacture versus Controller General of Patents is the case to be discussed. This appeal has been filed by this particular appellant against an order dated 9th August 2020. The appellant applied for patent during their 97 and it was granted during their 2006. He did pay the renewal fee from 3rd year till 10th year, on 12th December 2006. Renewal for 11th year was also paid on 1st August 2007. But the 12th year, the renewal is where this particular cause of action arose, where this restoration application was filed. But the period of 18 months had lapsed on 1st Feb 2010. But this particular restoration petition was filed on 13th April 2010. Patent ideally ceased to have effect after 1 year of making this payment, which is on 1st August 2008. An application was thus required to be restored within 18 months, and the last possible date was 1st February, but the actual date of submission was 13th April. The learned counsel appearing for the appellant submitted that according to the new amendment, there is this provision of 18 months from the date of cessation. An extended period of 6 months is provided, which was not then prevailing under the previous law. According to the learned counsel, old law shall be applied. That is, the controller of patents representing them, they said that the old law was prevailing for this particular case, and the date of cessation is thus dependent on the actual date of making the renewal fee payment. But appellant was of the view that the renewal fee and extension could be availed as per the extent provision, that is the new provision, and the old provisions were already lifted. The learned counsel, however, relied on various other judgments coupled with the fact that the consideration of old act should be reckoned, though the new act had already come into force. Thus, the judgment was made on 13th September 2012, which held the fact that the appellant had a chance of filing this Form 4 for making an extension of payment of renewal fee for a period of 6 months and have this patent renewed, which lapsed on 1st Feb 2009. The appellant also had another chance of that 18 months, which also lapsed on 1st Feb 2010. Thus, the patent ceased to have effect by virtue of the statutory provisions, and the date of cessation of patent could thus not be changed, and appeal was thus dismissed. And both this particular extension of 6 months, which ended on 1st Feb 2009, and that 18 months, the extended time frame of 1st Feb 2010 was also not complied with by this particular patentee, and he made a delayed submission on 13th April 2010, and hence this particular cessation of patent was held to be not changed. Friends, with this we are concluding this week's webinar. We will conclude. If you have any questions, I'll be glad to take. Otherwise, we will see in the next week webinar continuing with the patents. Thank you very much. Take care. Stay safe.